The following presentation aims to describe the legal purpose of the enclosed C, together with the name of the owner and the date of first copyright, referred to as copyright notice or copyright formalities. So the legal background. In Australia, the Copyright Act of 1968 enables that copyright is free and automatic, and it begins on the material creation of the works, or when the works become in material form. As it is on creation, a copyright notice is not mandatory under Australian law for copyright to exist, therefore not generally required. Where did it come from? Australia is party to several international treaties that exist to deal with intellectual property rights internationally. Of this principle is the Berne Convention. The Berne Convention embeds the idea that copyright exists upon creation. This didn't sit well with all countries, not all of which subscribed to it. Others, including the USA, became party to subsequent treaties. For example, the International Copyright Convention, which had the ability to require, if the local country laws required so, that copyright notice was required for copyright to exist. So to benefit from copyright protection overseas from those countries that used the Universal Copyright Convention, or not recognise the Australian Copyright Act, or protection, the use of the copyright symbols and the name and year published, or the copyright formalities, where advantageous. Much of this has fallen away in recent years. The US is now party to the Berne Convention, and international trade agreements generally or largely align copyright obligations internationally. So, not required, but it still can have some merit. It can be informative. It can make known who the owner of the copyright is and what date the copyright began. This allows anyone wanting to use the works to determine the path or the start of the path to achieve permission. By way of an example, CD shows that it's copyrighted, when it was copyrighted, and by whom it's copyrighted. As well as informative, they can be protective. The Copyright Act uses its terms within Section 37, 38, and 102 and 103 to define an infringement. If a person or importer knew or ought reasonably to have known that the making of an article constituted an infringement of copyright, it's hard to not know if it's written on it. These copyright formalities have some practical value as deterrent against infringement. Where the copyright notice provided, it falls to the defendant in infringement proceedings to demonstrate that copyright did not subsist or is not owned by those identified, so the onus becomes on the defendant. And it simply serves as a reminder that it is subject to copyright and permissions may be required. Thank you.